Hey everyone, Mike Harris, Director of Public Policy for Gun Owners Action League, and I am thrilled to be joined by my friend Dan Hagan.
Hi everyone.
And to introduce yourself a little bit.
Yeah, so I'm Attorney Dan Hagan. I practice primarily in the western part of the state, pretty much from Worcester area to the Berkshires. And I do, my focus is on firearms-related law, both criminal firearms cases and license cases, LTCs, FID cards, and the like. My practice is pretty heavy with criminal. I do other things besides gun cases, but I do keep a pretty heavy presence with guns. But I do murder on down for
murder on down. What That's a phrase! No, so you've been kind of one of our go-to guys for a little while with a lot of this stuff. We called on you for the Kyle Culotta case.
Yes.
Anytime I have a
Still
question,
working on that one. We're on it.
Still, I mean, you've done a lot of impressive work on that one. Anyways, I mean, getting the larger stuff dropped.
Yes, the most
in the
serious
Superior
charges.
Court
Yes,
that's huge. That's like almost unheard of in Massachusetts. Like you're doing the work. You're out there, and you're the one who's actually.
We got to get him home. There's no win until he comes out of that.
Agreed.
Out of jail. So.
But no, But regardless, just that piece of it is a big win. I think. Knowing the landscape of the state in general. From the courts all the way to the legislature and what the intent of those laws are.
Yes,
it's kind of a big one.
Our laws in Massachusetts are certainly laid as a trap for out-of-state folks who come in here unknowingly, and next thing you know, you realize you're charged with felonies and mandatory minimum jail time. Yeah,
and it's funny. So I had a conversation with Jason Guida, who's another one of our attorneys that we work with. Jason.
Great guy.
Yeah, he's awesome. But he practices mostly out in like the eastern part of the state,
yes.
And he called me one day and he was like, "Hey, he's like, you gotta listen to this." He's like, "There's Marion Ryan's office in Middlesex County has come out and said that they will not be pleading this stuff down anymore for out-of-state folks."
Yes.
And I called you and I was like, "Hey, this is happening." And you were like, "Yeah, we already knew that.
Yeah.
They already told us that out in Western Mass.
Yes,
We're already screwed out here."
Yeah.
I was like, "Oh, all right."
Yes, district attorneys' offices that I work with, that is a common issue around Massachusetts. So remember, we're not just up against the law here, but we're also up against how the law is being applied. And these district attorneys' offices, I hold them just as accountable as a legislature for in the court system for these things, because they don't differentiate between the guy who just comes over the state border, who's otherwise a lawful gun owner in their home state, comes over the border by a mile. He's being treated as a felon facing mandatory minimum jail time, just the same as people who have records in here in Massachusetts who are gang members, other things, other people like that. There's no differentiation between those two people. And as you said, there's like a zero tolerance policy in a lot of it, where they will refuse to budge on giving the poor person any consideration for just having to come over the border by a few miles.
And exactly. And I know this isn't the world that you kind of live in, but it's ideological. It absolutely is. I mean, we were just talking about the Earler case a few minutes ago, and that's the case where I was talking about yesterday, where the Court of Appeals determined that your defense attorney no longer has to advise you of the implications on your gun rights of you pleading guilty to even a first-time OUI charge. And you said, "Oh, well, it's still mandated that they have to apprise you of the implications on your immigration status."
I mean, what a terrible decision that the appeals court made. Yeah, if you're an illegal alien here in Massachusetts, you're apprised, and in fact, anyone is. It doesn't. Yeah. I'm not just saying illegals, but they make sure that they tell you if you are not a citizen of the United States and you get convicted of a crime, then it's practically inevitable that you will face deportation. And so they advise you of all your immigration consequences. Both your defense attorney has to advise you, and then also the courts, the judge actually goes through a colloquy with the defendant over those rights. So for an illegal alien, their rights they're being advised of the consequences to their plea. But for a citizen here in the United States,
whose civil rights are at risk.
Correct. Your fundamental constitutional rights are being lost, and you don't have to be advised of that. It's just a horrible decision.
But like I said, I know this is not the world that you play in, but to me, that just throws it into stark light that this is an ideological issue. I mean, it like top to bottom in this state. It's just not. This is what Justice Thomas was talking about when he said that the Second Amendment should not be treated as a second class right. Sure. And it's this stuff exactly that he was talking about. So I think Erler has grounds on Bruin grounds to be challenged, but where it stands right now.
Yeah, I mean, it's not good. As you said, it
feels so petty.
Yes, well, the court system, and you can ask anyone who's in there practicing and knows anything about firearms, would tell you that you read these appellate decisions in these courts in Massachusetts, and there is judicial somersaults of logic going on just because they have a problem with guns and they do not want to recognize the right as a full-throated constitutional right, and that's really unfortunate here, but I think things are changing. Hopefully, we're going to have some change coming. I think the U.S. Supreme Court's going to give us some changes here coming up in the next few terms, which will hopefully start to rework these laws a
little bit.
That's right.
It feels like we're going. It feels like we're progressing in, the expansion of fire. I shouldn't say the expansion, but the expansion of the respect of the Second Amendment. But also, like when you're getting to a point where you have to write this stuff down, it's kind of depressing. It feels like it's been like kind of a cultural change. Yeah. Because we, back before the '98 bill was passed, and even like the NFA in the 30s, it was really just assumed that you had all of your rights until you proved that you shouldn't anymore. But now it seems like, most people who are in power at this point don't feel that way anymore. So we need to start writing this stuff down to make sure that they understand that better.
Yeah. Yeah, well, I mean, just to give you how bad the state was, I mean, up until Bruin and a decision after Bruin, Gordato, here in the state of Massachusetts, based on Bruin.
Right.
Remember, prior to that, they could arrest you and charge you with having an illegal firearm or having a firearm without a license, and it was your job to prove you were licensed, not their job to prove that you were not licensed. So that was an affirmative defense here in Massachusetts was licensure. So that's, we are chipping away and things are happening, but when you have a state as bad as Massachusetts, it's going to take a little time. Yeah, so
I hate to do this to you, but can you expand a little bit on what an affirmative defense means? Because that's kind of a big one when you're talking about firearms laws, because it's not a passive thing. Like you need to assert that at the beginning of a trial in order to use it most of the time, right?
So you have to establish it at trial. Yeah. So how it works is if you're charged with a crime here in Massachusetts, every crime has certain elements to it that the prosecutor must prove beyond a reasonable doubt. If you say nothing as a defendant, they still have to prove beyond a reasonable doubt all of the elements of the crime. And prior to some changes here in Massachusetts in the wake of Bruin, they did not have to prove that you lacked a license as part of convicting you for unlicensed possession of a firearm. So what an affirmative defense and what was required of you at that time, and there are still affirmative defenses in our firearms laws now, things that are considered exemptions, the courts look at as something that you have to establish as an affirmative defense. And affirmative defenses is required for the defendant to put on evidence at trial to establish the defense. And once the defense has been established, then the prosecutor has to disprove that defense if you can establish it beyond a reasonable doubt. But the burden falls to you. And it was sort of crazy when you're charged with unlicensed possession of a firearm, but it was your job to prove you actually had a license, not the prosecutor's job to prove beyond a reasonable doubt that you didn't.
That you didn't, yeah.
Everything is backwards.
Exactly. I mean, it just feels like the burden is where it shouldn't be. It's just a funny little. Looking at it as like a pure like intellectual exercise, it's kind of just a weird interesting quirk that they put on this stuff in to hone their ideological bent.
Yes. Yep. But they'll take and they'll take something and say, okay, if there's any kind of new decision from the Supreme Court, they will try to limit that as much as possible. And that's what happened in the wake of Heller. They say, okay, well, the right of, to possess a firearm, that's just within your home. You can have it in your home. You can't walk around with it.
No.
You can have it in your home. And so obviously that changed in the wake of Bruin. And so then they start to move and they'll start to try to limit Bruin as much as possible in their decisions.
And we're already seeing that.
Correct.
I mean, Chapter 135 is complete, evidence of that.
Yes.
But just to go back for a minute, so you had said things are looking up in certain areas, and that was actually a perfect segue that I ruined into the reason why you're here today. So first off the bat, just to embarrass you a little bit, congratulations! This was a huge win.
Thank you.
Commonwealth v. Santana-Rodriguez. We keep saying this. Jim and I were talking about this. Self-defense in Massachusetts looks very different this week than it did last week, and it is pretty. It does. It's kind of all thanks to you and your legal team and the yeoman's work you guys did.
Yes, and I can't take full credit for this. I argued it in front of the Massachusetts Supreme Court.
But they even said how great your brief was at the beginning of the oral arguments, which I will put a link to down the bottom.
They did, and
it's awesome.
The person who primarily authored that brief is an attorney that I work with, Kyle Culotta, great young attorney, very good researcher and writer. So he was involved in the case pretty heavily, and as well as Dan Kelly, who's an amazing attorney out in Springfield. One of the best attorneys.
You guys are like the dream team. It's awesome.
Yeah. So we were very fortunate that the Supreme Court saw it our way and made the decision they made. But I think it's a decision that makes sense to those if you really understand the issues. And I do think it provides new protections for those that are legally and lawfully exercising self-defense.
Yeah, so let's get into it a little bit. So kind of, I think most people who are watching this know the background, but if you're not, we'll get into it a little bit. So correct me if I get any of this stuff wrong. So the gentleman is in a salon getting a pedicure, poor guy, with his girlfriend or not. I don't know. There's some.
He was with a female acquaintance and that becomes kind of the center of the dispute as to the nature of the relationship.
So he's in there with this girl, and her current ex whatever it is, boyfriend comes in, starts assaults the Mr. Santana-Rodriguez and starts making some threats, and he.
So my client Kenneth Santana-Rodriguez, he was his back up against the wall, as you said. He was getting a pedicure when, at that moment, the ex-boyfriend of the female acquaintance he was with came charging into the nail salon and began to assault him. I mean, all witnesses saw that he struck him. And that he then reached for his waistband and showed him a firearm and said, what's about to happen. And at that moment, you have obviously split seconds to react because this individual has a very long record. And so he, at that moment, had a life or death decision to make, and he ultimately pulled out his own firearm, legal firearm. Kenneth had an LTC.
Yeah, it even mentions in here that it was only 10 rounds. They made a point to specify that it was a 10-round magazine with only 8 left.
Yeah, licensed and lawful gun owner, trying to do everything right.
Yeah.
In that moment, though, his life was imminently threatened. He pulled out his firearm and he fired. The problem is he fires 2 shots, but one of them hits the nail technician who was working on them. And remember, this is close quarters, so you have you have a nail technician, you have this person attacking you, things are happening very quickly. Obviously, if your life is being imminently threatened, he missed and ultimately and sadly killed the nail technician, which I think is a tragedy. We really should.
It's terrible.
We should really say that this is an innocent bystander, and we take no. I mean, this is a horrible thing that happened, and Kenneth, I know, feels horrible about the
I mean, what a nightmare
it is.
On top of, like, I got to be honest with you. I would feel terrible, like, even if I shot the guy who was coming at me. I mean, that's still something that you have to struggle with.
Yes.
And to hit an innocent person is just a nightmare of nightmares.
The day that you have to draw your firearm out is the worst day of your life,
Unquestionably.
Right?
I mean, we all carry them hoping that we'll never have to use them.
That's correct. Yeah.
And, but yeah, I mean, so until this decision, what would happen to you if that happened to you?
Sure. So this is what happened in Massachusetts. It was unclear, and that's why we are here in the Massachusetts Supreme Judicial Court. The law in Massachusetts for 250 years has never determined if you are claiming self-defense in a situation where somebody other than your attacker was killed, whether you can actually use that defense. So it was never affirmatively established. The court, the few times that it was ever brought to their attention, in fact, one time specifically, the court just punted on the issue and said, well, they kind of wiggle their way out of it, saying, well, we don't really see the facts here, meaning self-defense, and so it doesn't apply. So they have punted on it up to this point. And so this case presented a great situation because, again, Kenneth has no record. He has an LTC. He rendered first aid. He called the police. He stayed there till the police showed up, did everything right. And the prosecution admitted that self-defense here is on the table. And and had he shot the actual attacker, then yes, self-defense would be something he could argue. So it was a clean case that the Mass Supreme Court could consider, and ultimately made the decision that we could, because up until that point, it was unclear. It would be up to the trial judge if he would allow us to argue self-defense.
To even argue self-defense.
Right. So we don't. Right. So it's sort of a situation where you don't want to be left with, at the moment of trial, saying, thinking you're going to argue self-defense, and then suddenly that is taken away from you. Off the table. Right. Off the table, saying, well, no, the person that you killed was not attacking you. And up until a couple of days ago in Massachusetts, that was a very possible outcome. And
that's actually something that a lot of people don't understand is when I'm sorry to turn this into like a criminal procedure.
No, I just got over my nightmares of law school, and now you're bringing them back. So that's great.
But no, it's a lot of people don't understand that you can't just bring all of the defenses you want to the table.
Yeah.
It's really, a lot of times it's up to the judge looking at the situation and the evidence who gets to determine what you get to argue.
That's correct. I mean, the judge sits and hears the evidence in the case, and if they don't hear evidence of self-defense, they won't charge the jury. They won't give the jury instructions on self-defense. So there has to be facts that are implicated in the case to allow you to argue self-defense. And in this case, again, it was an open question whether you could argue self-defense, and a jury could be instructed on self-defense if you kill the wrong person. And I think gun owners in Massachusetts should also think of it like this. Like the scenario here, obviously Kenneth killed the wrong person and missed his target. But this situation also would apply in a case where you shot the right target, but it went through that person and then killed somebody else. And in that case, you could still be charged with murder. And up until a few days ago, it was a question as to whether self-defense could even apply in that situation. And that's where you actually hit your attacker, and there's no question that you hit the right person, and it was well beyond your control where the
round goes after
that. Correct.
Yeah. So let's kind of get into you'll hear the term transferred intent thrown around when you're looking at this case a lot. So just a little bit of run through of what that is.
Yeah, so transferred intent is basically where if my intent to shoot or kill one person, if I miss or I, in doing so, kill a second person, my intent to kill the first person is transferred to the second person who I actually killed.
Right. So this is different than a felony murder issue. So, felony murder is if somebody is killed by anyone during the commission of a felony, the guilty or the defendant could be charged with murder. This is actually a completely different type of charge where if you had shot at somebody with malice and intending to kill them and you shot a different person, that malice and intent to kill would transfer to the other person. In this case...
Well, and just to not interrupt you, but otherwise it's a necessary sort of legal fiction, because if you didn't have that, the argument would be, well, I didn't intend to kill the other person. I had no intent to kill them. And so the law has to account for, okay, yes, you tried to kill X, and that person was, you had malice and you were intending to kill them, and you missed and hit another person. We're not going to allow you to just argue that, hey, you know what, I didn't intend to kill the second person. You're not getting out of it like that.
Yeah, you intended to kill someone. Just because you hit the wrong guy doesn't mean that intention goes away, which brings the self-defense argument kind of full circle on this case, what we're talking about right now. So self-defense scenario is lawful intent when you're speaking about the law. So if you have a lawful intent to shoot someone in a lawful set of circumstances, and if you had hit your attacker, I mean, in Massachusetts, you probably would be charged anyways, but if you hit your attacker, you would be able to argue that self-defense, and self-defense is, again, lawful intent. So in this case, the transferred intent to the innocent bystander was a lawful intent to defend yourself.
That's right. That's right. And the basic principle, so just to go back to like the whole transfer intent is, and the question really in this case was, okay, your intent to kill may transfer. Okay, but do your defenses to that also transfer?
Right.
And, if you can argue self-defense, it negates malice.
Exactly.
And it's a lawful act. And so in that, and this is what we argue to the court, is that, okay, in your mind, if you, and remember, as a precondition to this, the jury has to have found that you were actually defending yourself against the person that was attacking you. But
so it's not automatic.
No, it's not
by
automatic.
Any means.
Correct. And I think some people who don't read the opinion or don't dig into it think there's some, this is like going to create the Wild West out here or something.
Get out of jail free card.
Exactly. No, so the jury has to first, as a precondition, find that you were actually defending yourself.
Right.
Okay. And then the question becomes, if you miss that person, okay, does your intent here, which was self-defense, non-malicious, lawful act,
right,
when it hits the second person, how does malice come back into the equation?
Exactly.
And that's what we argue, to say, well, wait a minute, your intent should transfer just as if you were going to kill that first person onto the second person. The intent and the defenses all transfer. And that would be only fair to a defendant in that situation, in a life or death situation.
Yeah, exactly. And
but it's not without some caveats too, which we'll talk about. It may not be a complete defense in all situations.
Which is kind of fine, because when you do look at a situation like this, you do have to look at things like your surroundings, who's near you, sure. what happens to you physiologically.
Absolutely.
In this type of a situation. I mean, the adrenaline dump alone can kind of, to be nice about it, adjust the way you. I
mean, by definition, your life has to be imminently threatened with death or serious bodily injury in order to use self-defense. So think about what's going through your mind, or the acts you have to take in that moment, and how mistakes can be made, because it's so urgent and so life
so immediate.
Yes.
And so to get into those caveats, I mean, because what we're talking about here is recklessness and negligence. So if you're, I mean, if just to kind of, if I'm not wrong.
Yeah, no, you're right.
If you provided all of the other elements are there, but you don't take into account, the fact that there's somebody standing right behind this guy holding them, or if you're just kind of wildly shooting, or you don't know what the hell you're doing. There's also the possibility that this defense could not be complete, like you said, because you have acted recklessly or negligently. So if you want to get into some of the specifics on that one.
Yeah. So, okay. So in a situation like this, the defense is, the way the Mass Supreme Court just established this defense is, if you're acting in self-defense against your attacker, okay, murder then is off the table. If a jury finds that, murder is now off the table. Then the question becomes, is it an acquittal in that situation, or could it be involuntary manslaughter? And involuntary manslaughter involves a substantial risk of injury to others, and that's what that's a recklessness. A recklessness standard is what was needed in order to convict you of involuntary manslaughter. And so it's up to a jury to decide if this was simply an accident, or whether there was some recklessness, something more than just an accident, more than just mere negligence. Now, what the government was arguing was saying, well, okay. You miss if there was no negligence. They try to make it a negligence standard. If there was no negligence, okay, we could see an acquittal there. But even negligence, suddenly that raises things to a second-degree murder, because they wanted to treat the person who's defending themselves lawfully in an act of self-defense where their life is imminently threatened. They wanted to treat that person the same as somebody who just on their own discharges a firearm into a building that they know is occupied, or into a crowded room. Because by definition, when you do that, shoot into a crowded room or shoot into an occupied building, that is a second-degree murder if you kill somebody. Even if you say, well, I wasn't intending to kill someone. No.
And that's a relatively new law, I think. They just adjusted that recently, right?
It's called third prong malice.
Yeah.
And third prong malice is saying
Sorry, I didn't mean to get you off track.
No. But your actions were so reckless in that moment that you basically are going to be treated as a second-degree murderer.
Right.
And so the government was saying is, basically, if you have no carelessness at all, no negligence at all, which, by the way, which is what I said to the Mass Supreme Court, would swallow the rule, because in every case you've hit the wrong person, right?
Right, yeah.
So remember, negligence is like a car accident, it's like a fender bender. Like there's some carelessness that may go into this because your life was very close to ending.
Right.
So the court thankfully did not take the government's invitation to lower the standard to negligence, and also what the government was suggesting is say, okay, if you were at all negligent, you're a murderer still. And they did not take their invitation. They said, no. If you are, you have to be reckless. And if you're reckless, then it's a involuntary manslaughter. Otherwise, if it was just an accident, even if you were careless, a little bit careless, it's an acquittal.
Yeah.
Which is huge for gun owners.
That is huge.
And people defending themselves. Yeah.
It's kind of the fundamental of self-defense. I mean, making sure that, after the fact, you can still defend yourself.
That's right.
I mean, because after you're over the physical danger, there's the legal danger. And that's still, in your mind should still be the mindset of self-defense, because nobody really going to jail is a bad thing that happens to you.
Absolutely. Because you can still be charged with, and in this case, first-degree murder. He was charged with, and you're still going to sit in jail.
Right.
And the day that, like I said, the day that you have to pull out your firearm, and especially if you have to use it, is the absolute worst day of your life. And you will be held likely without bail, and then it's up to you at trial to establish some of these things. But at least there's an outlet, and because before, if this happens and an accident occurs while your life is threatened, you may have had no outlet, and again, it was never firmly established whether you did. And I think it's important to think about things like this. Like in every one of these cases, we have a victim. Somebody has died, and they're not the right person has died, so that person is a victim. Yeah. But I think the court acknowledged, and what is right here is to think about who's the first victim. Right. The first victim was the person whose life was imminently threatened, who was seconds away from having their life ended. They're also a victim. They're the first victim. And so there has to be some mitigation there to that person who had to act in that moment.
And that was kind of the through line of your argument. It seemed like when you were in front of the court, it was you hit on a theme. They tell you in law school when you're up there arguing, you need to hit on a theme and just kind of keep driving it home. And you did a great job at that. And like I said, I'm going to put the link to Dan's oral arguments down below on this. It's on YouTube. You can take a look at it, and I recommend that you do. It's fascinating to see how this stuff actually works.
Yes, the process in action.
Yeah, the process in action. Yeah. And I would recommend that you guys all watch that if you get a chance to. It's only like 20 minutes long. It's not going to take you a ton of time.
Yeah, it's about a half an hour.
Yeah, it's about a half hour.
Yeah.
You guys you hit this one out of the park, man.
Thank you.
You did a great job. This is a big win for firearms owners in Massachusetts who want to carry a gun for self-defense, which we all recommend that you do if you are trained up and you know what you're doing.
Yes.
It's definitely a big responsibility to take on, but
step by step, we're clawing the rights back here in Massachusetts, our fundamental rights back the best we can. So as I said, it's a slow process, but we're fighting every day. Yeah,
and this is just a little bit of breathing room that you and your team coaxed out of the SJC. So we appreciate you guys, and this was awesome. Thanks for coming in,
commenters in the Boston Globe are not happy, so you did something right.
That's a great... if you judge a man by his enemies.
If you do that, then you know, right.
So, no, seriously, thanks for sticking around, guys. Dan, is there anything else you want to hit on?
No, I think we covered the waterfront.
Yeah,
so
there you go. What's your website?
Sure. My website is www.massgunlawyer.com. You can contact me there, and I'm very responsive. You can book an appointment right with me online.
And we'll also put that link down below too. But if you want to, you can go through the gold.org website and go up to 2A attorneys, and Dan is like number 2 or 3 on the list on that. So we did it by region. It has nothing to do with where you are on the list. But yeah, it's you can also find him through our website if you want to take a look. But yeah, if you're ever in a spot of bother, this is one of the guys you want to call. So All right. Thanks a lot, Dan.
Great.
Appreciate it.
Yes,
Thanks
absolutely.
for coming
Thank
down
you,
on a
Mike.
Friday.
Thank you, everyone.
All right. Thanks, guys. Bye.